Okay, so sometimes I actually do something else, and this is already reported in the legal system. Just want everybody to understand that what I'm saying there is that you know attorney-client privilege gives the attorney, he's free from prosecution for not turning over even the most heinous evidence. I mean, like say he knows that so and so murdered somebody. Okay, but it doesn't give him immunity from investigation. I mean, otherwise, every criminal in the world would just get their lawyer's degree and pass the bar and say, hey, I don't have to give you anything, or whatever. I mean, it just seems like there's if you make them free from prosecution, or I mean, basically you make them free from investigation, then they're free to do whatever they want, break any laws they want, and not be investigated, right? That's one thing. So it does protect them in terms of they don't have to hand over the client information, but it doesn't protect them from being investigated, which includes a judge giving a warrant. I mean, it seems to me like it protects them from everything that I've seen in my experience with the legal system, that it protects them from, like, if they're being questioned, if they're giving testimony, all that kind of stuff. If a judge is pressuring them to give the client information, uh, and so if he's pressuring them to give the client information, but then he goes to another judge or he issues a warrant, well, yeah, the warrant has to be in good standing. The warrant, so regardless of privilege, if a judge can produce a good warrant, which obviously Congress and lawmakers, Supreme Court, etc., need to decide what is a good warrant, right, and what is just invading attorney-client privilege. So, and I would say that they would probably come to the conclusion that if there's criminal uh, criminal behavior suspected and the judge decides to issue a warrant, they can do it. I mean, they can already just throw the lawyer in jail. For, they get away with it. I don't know that it's legal. I mean, I suppose it is, but they do it. But they don't get away with it for very long. I mean, they don't get to throw a lawyer in jail for life for not reviewing attorney-client privilege.
Office, him a, a client attorney privilege applies to what he does. It doesn't apply. It doesn't mean that the police or whoever's investigating can't get a subpoena and and search a lawyer's office isn't somehow like off limits just because he's got attorney-client privilege. No, they they just can't make him talk. They can go in and raid an office and take the stuff. If he doesn't have the brains to take all the tapes and everything and hide them away somewhere where they won't find them, then that's his stupidity, right? That he should have made sure they were gone. Now, As to whether a at any time whether some judge should give a warrant, a search warrant, that's a whole nother matter, and I'm sure we'll get into that sometime since I have my little site, my little Facebook group about, or page or whatever it is, about surveillance, NSA, and all that kind of stuff. But as far as, yeah, I mean, and just saying that they got a warrant is good enough. No, I mean, any warrant can be scrutinized, right? But for sure, if the warrant was fair, so if they had reasonable reason to believe that crimes were being committed.
Yeah, just rehashing, saying the same thing that I said a minute ago in more detail. So let's jump ahead a little bit.
I think that pretty much covers it, and I think that the way